1. The presiding judge shall seek an opinion from the prosecutor concerned before she makes a ruling on whether to release on bail. Less than amended on June 1, 2007 greater than. 2. The preceding paragraph shall also apply to a ruling on cancellation of detention, except for the cancellation upon a motion of prosecutors and emergency situation. Less than amended on December 29, 1995 greater than. 3. Upon receipt of a request for her opinion under paragraphs 1 and 2, the prosecutor concerned shall communicate her opinion without delay. Less than newly inserted on June 1, 2007 greater than. 4. The prosecutor concerned may file an immediate complaint against a ruling to cancel detention. Less than amended on December 29, 1995, June 1, 2007 greater than. This article wholly amended on January 25, 1973. 93 Hun Ga 2, December 23, 1993. Act No. 2450, January 25, 1973. Article 98, Conditions of Release on Bail. When a court grants a permission for release on bail, it shall put one or more conditions out of the following conditions to the extent as may be necessary and appropriate. Less than amended on December 8, 2020 greater than. 1. The criminal defendant shall submit a letter of undertaking to promise that she shall not destroy evidences and make an appearance before the court at the time and place designated by the court. 2. The criminal defendant shall submit a letter of undertaking to promise that she shall pay an amount equivalent to the bail determined by the court. 3. The criminal defendant shall accept measures taken by the court to prevent her from escaping by circumscribing her dwelling to a place designated by the court or to require her to obtain permission from the court if it is necessary to change such dwelling. 4. The criminal defendant shall not commit any act of doing harm to the life, body, or property of a victim, a person who is deemed to know a true fact necessary for the trial of the case, or a relative of such person, nor approach the residence, workplace, or neighborhood of such person. 5. The criminal defendant shall submit a letter of guarantee prepared by any person who is not the criminal defendant for assurance of the criminal defendant's appearance. 6. The criminal defendant shall take an oath that she would not go abroad without obtaining permission from the court. 7. The criminal defendant shall deposit an amount of money required for recovery of the victim's rights or offer an asset equivalent to such amount as collateral in the manner specified by the court. 8. The criminal defendant or a person designated by the court shall pay the bail or offer an asset as collateral. 9. The criminal defendant shall fulfill other conditions placed by the court as appropriate for assuring of the defendant's appearance. This article wholly amended on June 1, 2007. Article 99. Factors to be considered in attaching conditions to release on bail. 1. A court shall take the following factors into consideration in attaching the conditions under Article 98. Less than amended on December 8, 2020 greater than. 1. The nature and circumstances of the crime. 2. The probative value of evidence against the defendant. 3. Criminal records, character, background, and assets of the criminal defendant. 4. Matters relating to circumstances after committing the crime, such as compensation for victims. 2. A court may not put any condition that the criminal defendant is unable to fulfill by her financial ability or with her own assets. Less than amended on December 8, 2020 greater than. This article wholly amended on June 1, 2007. Article 100. Procedures for execution of release on bail. 1. A ruling for permitting the release on bail may not be executed unless and until the conditions under subparagraphs 1, 2, 5, 7, and 8 of Article 98 are fulfilled, and a court may, if deemed necessary, make a decision to execute the permission for release on bail only after other conditions, if any, are fulfilled as well. Less than amended on June 1, 2007 greater than. 2. A court may permit a person other than the person demanding bail to pay the bail money. 3. A court may permit substitution of bail money with negotiable securities or a guarantee letter submitted by any person other than the criminal defendant. Less than amended on June 1, 2007 greater than. 4. a statement that the bail money shall be paid on demand shall be entered in the guarantee of the preceding paragraph. 5. A court may demand an administrative agency or any other organization, public or private, to take appropriate measures as may be necessary for a criminal defendant who is released by its ruling for release on bail to fulfill the conditions of the release. Less than newly inserted on June 1, 2007 greater than. Title amended on June 1, 2007. Article 100-2, Administrative fines on appearance guarantors. 1. If a defendant who was released by a ruling on release on bail under the conditions set forth in subparagraph 5 of Article 98 does not make an appearance on a designated date without any good cause, the court may impose an administrative fine not exceeding $5,000,000 on the guarantor who assured the criminal defendant's appearance by its ruling. 2. An immediate complaint may be filed against a ruling under paragraph 1. This article newly inserted on June 1, 2007. Article 101. Suspension of execution of detention. 1. When a probable cause exists, a court may, by its ruling, suspend the execution of detention by placing the criminal defendant under the supervision of relatives, protective institutions, and/or other proper persons, or restricting area of his/her dwelling. 2. Before making the ruling referred to in paragraph 1, the court shall seek opinions from a prosecutor, provided that in case of emergency, the same shall not apply. 3. Deleted. Less than July 31, 2015 greater than. 4. If a motion for release is made for a member of the National Assembly who is detained pursuant to Article 44 of the Constitution of the Republic of Korea, execution of warrant of detention shall ipso facto be suspended. Less than amended on December 18, 1980, November 28, 1987 greater than. 5. The Prosecutor General who receives the notification of the motion for release referred to in the preceding paragraph, shall immediately direct the release and notify the competent court of the reason therefor. This article wholly amended on January 25, 1973. Less than paragraph 3 of this article was deleted after the decision of unconstitutionality by the Constitutional Court made on June 27, 2012 in accordance with Act No. 13454, July 31, 2015 greater than. Article 102. Change of conditions on release on bail and revocation. 1. A court may, ex officio or upon a motion from a person specified in Article 94, amend the conditions of release of a criminal defendant on bail or suspend the performance of the conditions for a certain period of time. 2. If a criminal defendant comes to fall under any of the following, the court may revoke the release on bail or the suspension of execution of detention, ex officio or upon a motion from the prosecutor, provided that the suspension of execution of a detention warrant under Article 101(4) may not be revoked during the session concerned. 1. If the defendant escaped. 2. If there are grounds enough to believe that the defendant is likely to escape or destroy evidence of the crime. 3. If the defendant did not make an appearance without good cause upon receiving a summons. 4. If the defendant did harm to the life, body, or property of a victim, a person who is believed to know a true fact necessary for the trial of the case, or a relative of such person, or if there are grounds enough to believe that the defendant is likely to do harm to such person. 5. If the defendant breached a condition placed by the court. 3. If a criminal defendant breaches any condition attached to the lease on bail without good cause, a court may impose an administrative fine not exceeding $10,000,000 on the defendant or may put the defendant in court-ordered confinement for a maximum period of 20 days by its ruling. 4. An immediate complaint may be filed against a ruling under paragraph 3. This article wholly amended on June 1, 2007. Article 103. Confiscation of bail money. 1. When a court revokes the release of a criminal defendant on bail, it may confiscate all or part of the bail money or collateral by its ruling, ex officio or upon a motion of the prosecutor. 2. if a criminal defendant who had been released under the condition to pay the bail money or offer an asset as collateral did not make an appearance or escaped upon receiving a summons after she had been sentenced to a punishment on account of an identical crime and the sentence was finally affirmed, the court shall, ex officio or upon a motion of the prosecutor, confiscate all or part of the bail money or collateral by its ruling. This article wholly amended on June 1, 2007. Article 104, Refund of bail money. When detention or release on bail is rescinded, or the term of the warrant of detention expires, the bail money or collateral which is not confiscated shall be returned within 7 days on demand. Less than amended on June 1, 2007. Greater than. Title amended on June 1, 2007. Article 104-2, Invalidation of conditions of release on bail. 1. When a detention warrant becomes ineffective, the conditions of release on bail shall also become invalid simultaneously. 2. When the release of a defendant on bail is revoked, the conditions attached thereto shall also become invalid as provided in paragraph 1, provided that the condition under subparagraph 8 of Article 98 shall remain effective. This article newly inserted on June 1, 2007. Article 105, Appeal and Ruling on Detention. In regard to a case for which the time for appeal has not expired or in which the appeal is pending, a ruling for renewal of the period of detention, rescission of detention, suspension of execution of detention or release on bail, or rescission of suspension thereof shall be rendered by the lower court so far as the records of trial are filed with the lower court. Chapter X, Seizure and Search. Article 106, Seizure. 1. If necessary, a court may seize any articles thought to be used as evidence or liable to confiscation, only when such articles are deemed to be connected with the accused case, provided that the same shall not apply where otherwise provided in acts. Less than amended on July 18, 2011. Greater than. 2. A court may designate articles to be seized and order the owner, possessor, or custodian thereof to produce such articles. 3. Where the object to be seized is a computer disk or other data storage medium similar thereto, hereafter referred to as data storage medium or such. In this paragraph, the court shall require it should be submitted after the data therein are printed out or it is copied within the specified scope of the data stored, provided that the data storage medium or such may be seized when it is deemed substantially impossible to print out or copy the specified scope of the data or deemed substantially impracticable to accomplish the purpose of seizure. Less than newly inserted on July 18, 2011. Greater than. 4. Where the court receives the data pursuant to paragraph 3, it shall inform, without delay, the subject of information defined in subparagraph 3 of Article 2 of the Personal Information Protection Act, of the relevant fact. Less than newly inserted on July 18, 2011. Greater than. Article 107, Seizure of postal matters. 1. If necessary, a court may seize or issue an order to produce postal matters or articles relating to telecommunications defined in subparagraph 3 of Article 2 of the Protection of Communications Secrets Act, hereinafter referred to as telecommunications, which are possessed or kept by a postal office or any other relevant institution, etc., only when such matters or articles are deemed to be connected with the accused case. Less than amended on July 18, 2011. Greater than. 2. Deleted. Less than July 18, 2011. Greater than. 3. When any disposition has been effected under paragraph 1, notification of such facts shall be provided to the sender or to the addressee, provided that this shall not apply if there is apprehension that such notification may obstruct judicial proceedings. Less than amended on July 18, 2011. Greater than. Article 108, Seizure of voluntarily produced articles. At articles which have been dropped or left, or voluntarily produced by their owner, possessor, or custodian may be retained without a warrant of seizure. Article 109, Search. 1. If necessary, a court may search the body of the criminal defendant, or articles, dwelling, or any other place of the defendant, only when they are deemed to be connected with the accused case. Less than amended on July 18, 2011 greater than. 2. A person other than the criminal defendant, or articles, dwelling, or any other place of the person may be searched, only when it is deemed that there are articles liable to seize therein. Article 110, Confidential Military Information and Seizure. 1. Seizure and search shall not be conducted at a place in respect of which military information shall be kept confidential, unless approval from the person in charge is obtained. 2. The person in charge referred to in the preceding paragraph may not refuse to grant such consent, except where compliance would be prejudicial to important interests of the state. Article 111, Official Secrets and Seizure. 1. In respect to articles held in the custody or possession of a person who is or was a public official, such articles may be seized only with the consent of such public office concerned, or its supervisory office, if the person or the public office to which she belongs or belonged declares that they relate to an official secret. 2. Such office or its supervisory office may not refuse to give such consent, except where compliance would be prejudicial to important interests of the state. Article 112, Professional Secrets and Seizure. A person who is or was a licensed advocate, patent attorney, notary public, certified public accountant, licensed tax accountant, public scrivener, doctor, herb doctor, dentist, pharmacist, druggist, midwife, nurse, or a religious functionary may resist seizure of articles held in his/her custody or possession in consequence of mandate she has received in the course of his/her profession and which relates to secrets of other persons, provided that this shall not apply if such other persons have consented to such seizure, or if it is necessary for important public interests. Less than amended on December 18, 1980, December 13, 1997 greater than. Article 113, Warrant of Seizure or of Search. A warrant of seizure or of search shall be issued where a seizure or search is to be effected other than in open court. Article 114, Form of Warrants. 1. A warrant of seizure or of search shall contain the following matters and the signature and seal of the presiding judge or commissioned judge, provided that where the articles to be seized or searched relate to telecommunications, the period during which such telecommunications are prepared shall be stated. Less than amended on July 18, 2011, December 8, 2020 greater than. 1. Name of the criminal defendant. 2. Name of the offense. 3. Articles to be seized. 4. Places, bodies, and articles to be searched. 5. Issuance date of the warrant. 6. The effective period, and the purport that the warrant shall not be executed after the lapse of such period and shall be returned to the court of issuance. 7. Other matters prescribed by the Supreme Court regulations. 2. Article 75, 2, shall apply mutatis mutandis to the warrant referred to in paragraph 1. Less than amended on December 8, 2020 greater than. Title amended on December 8, 2020. Article 115, Method of Execution of Warrant. 1. A warrant of seizure or of search shall be executed by a judicial police officer under the direction of a prosecutor, provided that the presiding judge may order court officials to execute the warrant if necessary. Less than amended on June 1, 2007 greater than. 2. Article 83 shall apply mutatis mutandis to the execution of a warrant of seizure or of search. Article 116, Notabilia. In the execution of a warrant of seizure or of search, the person who executes it shall protect confidential information of other persons and shall take necessary caution not to defame persons upon whom the warrant is to be served. This article wholly amended on December 8, 2020. Article 117, Assistance for Execution. In the execution of a warrant of seizure or of search, court officials may, if necessary, request assistance to judicial police officers. Less than amended on June 1, 2007. Greater than. Article 118, Presentation of warrant and delivery of copy. A warrant of search and seizure must be presented to a person subject to a disposition, and where a person subject to a disposition is a defendant, a copy of such warrant shall be delivered, provided that the foregoing shall not apply where a person subject to a disposition does not appear at the scene or it is impracticable to present a warrant or to deliver a copy thereof, or where a person subject to a disposition refuses the presentation of a warrant or delivery of a copy thereof to him, her. Less than amended on February 3, 2022. Greater than. Title amended on February 3, 2022. Article 119, Prohibition of entrance or leave during execution. 1. During the execution of a warrant of seizure or of search, persons may be forbidden to enter or leave the place. 2. Any person who does not comply with the prohibition of the preceding paragraph may be forced to withdraw or be placed under guard until the execution of the warrant is completed. Article 120, Execution of warrant and necessary measures. 1. In the execution of a warrant of seizure or of search, locks may be removed or seals opened, or any other necessary measures taken. 2. The measures of the preceding paragraph may be taken for the seized articles. Article 121, Execution of warrant and presence of parties. A prosecutor, the criminal defendant, or his/her defense counsel may be present when a warrant of seizure or of search is being executed. Article 122, Execution of warrant and notice of presence. Where a warrant of seizure or of search is to be executed, the persons listed in the preceding article shall be notified of the date and place of execution in advance, provided that this shall not apply in cases where a person prescribed in the preceding article clearly expresses his/her will in advance to the court that he/she does not desire to be present or in case of urgency. Article 123, Execution of warrant and presence of responsible party. 1. Where a warrant of seizure or of search is to be executed in a public office, military airplane, vessel or vehicle, the responsible person shall be notified to be present. 2. Where a warrant of seizure or of search is to be executed in the dwelling of a person, or in premises, buildings, airplanes, vessels, or vehicles which are guarded by persons, except as provided in paragraph 1, the owners, guards, or persons acting for them shall be present. 3. Where the persons referred to in paragraph 2 are not available, a neighbor or an official of the local public entity shall be present. This article wholly amended on December 8, 2020. Article 124, Search of female. When the body of a woman is searched, another woman of full age shall be present. Article 125, Restriction on execution at night. Before sunrise and after sunset, the dwelling of a person, or premises, buildings, airplanes, vessels, or vehicles which are guarded by persons shall not be entered for the purpose of the execution of a warrant unless the warrant includes a statement that it is to be executed at night. Article 126, Exception of limitation of execution at night. The restriction provided in the preceding article shall not be observed in respect to the execution of a warrant of seizure or of search in the following places. 1. Places which are considered to be habitually used for gambling and acts prejudicial to good morals. 2. Inns, restaurants, or other places to which the public has access at nighttime, but only during the hours when they are open to the public. Article 127, Suspension of execution and necessary measures. Where the execution of a warrant of seizure or of search is suspended, the place concerned may, if necessary, be closed or a guard may be placed there until the execution is completed. Article 128, Delivery of certificate. When a search has been made without discovering any evidence or articles liable to confiscation, a certificate to that effect shall be delivered on demand to the person who has been subject to such search. Article 129, Delivery of inventory of property. In case of seizure, an inventory of the seized property shall be made and given to the owner, possessor, or custodian of the property, or to the person corresponding thereto. Article 130, Custody and abrogation of seized articles. 1. In respect to articles seized which cannot be conveniently transported or held in custody, either a guard may be placed over them or the owner or some other person may be asked to voluntarily assume custody thereof. 2. A seized article may be destroyed or discarded if there is apprehension that they may cause danger. 3. A seized article may be destroyed or scrapped with consent of the owner or a person who has an authority to consent, if it is banned to manufacture, produce, possess, own, or distribute such article under statutes, and the article is perishable or it is impracticable to keep the article in custody. Less than newly inserted on June 1, 2007 greater than. Article 131, Notabilia. All appropriate measures shall be taken to prevent losses or damage, etc. to seized articles. Article 132, Keeping proceeds from seized articles in custody. 1. If it is anticipated that a seized article subject to confiscation will probably be destroyed, damaged, or perished, or the value of such article is likely to be significantly decreased, or if it is impracticable to keep the article in custody, it may be sold out and the proceeds from such sale may be kept in custody instead. 2. If it is impossible to determine who has a right to have a seized but returnable article returned or to find the whereabout of a person who has such right, and it is anticipated that the seized article will probably be destroyed, damaged, or perished, or the value of such article is likely to be significantly decreased, or if it is impracticable to keep the article in custody, it may be sold out and the proceeds from such sale may be kept in custody instead. This article wholly amended on June 1, 2007. Article 133, Return or temporary return of seized articles. 1. Seized articles which are no longer deemed necessary to seize shall be returned to the owner by a ruling, even before the completion of the accused case, and seized articles to be produced as evidence may be temporarily returned upon request of the owner, possessor, custodian, or presenter. 2. Where an article seized only for evidence is required to be used continuously by the owner or possessor, the temporary return of such article shall be made immediately after photographing it or taking other necessary measures to preserve its original status. Article 134, Return of seized goods to rightful owner. If a reason for return is apparent, wrongfully obtained goods shall be returned to the rightful owner, even before the completion of the accused case, by a ruling. Article 135, Disposition of seized articles and notice to party. In a ruling under the preceding three articles, the prosecutor, the rightful owner, the criminal defendant, or his/her defense counsel shall be notified in advance. Article 136, Commissioned judge and requisitioned judge. 1. A member of a collegiate court may be ordered to make a seizure or search, or a judge of a district court having jurisdiction over the place where such seizure or search is to be effected may be requested to do so, by a court. 2. Where the object to be seized or searched is not in the area under his/her control, a requisitioned judge may request a judge of another district court in the jurisdiction concerned to effect it. 3. As regards seizure or search effected by a commissioned judge or a requisitioned judge, the provisions related to seizure or search effected by a court shall apply mutatis mutandis. Article 137. Execution of warrant of detention and search. Where it is necessary for the purpose of executing a warrant of detention, insofar as there exists an exigent circumstance that makes it impracticable to obtain a warrant of search in advance, prosecutors, judicial police officers, or court officials under Article 81, 2, may enter the dwelling of a person, or premises, buildings, airplanes, vessels, or vehicles which are guarded by persons, for search of the criminal defendant. Less than amended on June 1, 2007, December 31, 2019 greater than. Article 138, Applicable Provisions. At Articles 119, 120, 123 and 127 shall apply mutatis mutandis to the search by prosecutors, judicial police officers, or court officials in accordance with the provisions of the preceding article. Less than amended on June 1, 2007 greater than. Chapter 11 Evidence by Inspection. Article 139, Evidence by Inspection. If it is necessary for the purpose of discovering facts, a court may effect an inspection of evidence. Article 140, Evidence by Inspection and Necessary Disposition. Persons may be examined, corpses dissected, graves opened, things destroyed, or other necessary steps may be taken to effect proper inspection of evidence. Article 141, Caution for Physical Examination. 1. In examining a person, due care shall be exercised not to damage the health and reputation of the person to be inspected, in consideration of the gender, age, condition of health, and other circumstances of the person. 2. The examination of a person who is not the criminal defendant may be conducted only when there is a cogent reason indicating a source of evidence. 3. Where the body of a woman is examined, a doctor or another woman of full age shall be present. 4. In cases of dissecting a corpse or of opening a grave, proper respect for the remains shall be observed, and the bereaved family shall be notified in advance. This article, wholly amended on December 8, 2020. Article 142, Physical Examination and Summons. A court may summon persons other than the criminal defendant either to the court or to other place designated for the purpose of examining the person. Article 143, Restriction of Time. 1. Before sunrise and after sunset, the dwelling of a person, or premises, buildings, airplanes, vessels, or vehicles which are guarded by persons may be entered for the purpose of inspection, only with the consent of the owners, guards, or persons acting for them, provided that this shall not apply when there is apprehension that the object of inspection might not be available after sunrise. 2. Inspection commenced before sunset may be continued after sunset. 3. The restrictions specified in paragraph 1 shall not apply to the places referred to in Article 126. Article 144, Assistance for Inspection. A judicial police officer may, if necessary, be ordered to assist in an inspection. Article 145, Applicable Provisions. At Articles 110, 119 through 123, 127, and 136 shall apply mutatis mutandis to inspection of evidence. Chapter 12 Examination of Witness. Article 146, Qualification of Witness. Except as otherwise provided in Acts, a court may examine any person as a witness. Article 147, Official Secrets and Qualification of Witness. 1. If, in respect to facts of which a person who is or was a public official has obtained knowledge in the course of his/her duties, either such person himself, or the relevant public office, declares that such knowledge relates to official secrets, he/she shall not be examined as a witness without the consent of the public office to which he/she belongs or belonged or the supervisory office. 2. The public office to which the person belongs or belonged or the relevant supervisory office may not refuse to give its consent, except where compliance would be prejudicial to important interests of the state. Article 148, Criminal Responsibility of Near Relative and Refusal of Witness. A person may refuse to testify when such testimony may be the cause of criminal prosecution or public action, or conviction for him, her or any of the following persons. 1. A person who is or was a relative. 2. A legal representative or supervisor of guardianship. This article wholly amended on December 8, 2020. Article 149, Professional Secrets and Refusal of Witness. A person who is or was an attorney at law, patent attorney, notary public, certified public accountant, certified tax accountant, public scrivener, doctor, herb doctor, dentist, pharmacist, druggist, midwife, nurse, or religious functionary may refuse to testify in respect to facts of which he/she has obtained knowledge in consequence of a mandate he/she has received in the course of his/her profession and which relate to secrets of other persons, provided that this shall not apply if such other persons have consented, or if the testimony is deemed necessary for the important public interest. Less than amended on December 18, 1980, December 13, 1997. Greater than. Article 150, Vindication of Reason for Refusal of Testimony. A person who refuses to testify shall offer presumptive proof as to his/her reason for refusing to testify. Article 150-2, Summon for Witness. 1. A court shall summon a person as a witness by serving a subpoena, communicating by telephone, electronic mail, or any other appropriate means. 2. A person who filed a motion to call a witness shall owe a duty to make reasonable efforts to make the witness appear before the court. This article newly inserted on June 1, 2007. Article 151. Failure in appearance of witness and administrative fines. 1. If a witness on whom a subpoena was served does not appear without good cause, the court may order the witness to pay the litigation expense incurred by his/her non-appearance, by its ruling, and may also impose an administrative fine not exceeding 5 million won upon him/her. The foregoing shall also apply where there exists the same effect as service of a subpoena pursuant to Article 76, 2, and 5, which is applicable mutatis mutandis under Article 153. 2. If a witness on whom an administrative fine under paragraph 1 was imposed by the court does not make an appearance again without good cause, the court shall put the witness in court-ordered confinement for a maximum period of 7 days, by its ruling. 3. A court shall summon a witness on the date set for a trial for court-ordered confinement and shall examine on whether there is any good cause referred to in paragraph 2. 4. The court-ordered confinement of a witness shall be executed by judicial police officers, correctional officers, court guards, or court officials in compliance with an order of the presiding judge, by putting him/her in a prison, a detention house, or a detention room in a police station. 5. When a witness is confined in a confinement facility under paragraph 4, after a trial to put him/her in court-ordered confinement, the head of the confinement facility shall notify the court of the fact immediately. 6. The court shall, upon receiving the notice under paragraph 5, hold a hearing for examination of witness. 7. When a witness gives testimony while he/she is under court-ordered confinement pursuant to a ruling on confinement, the court shall cancel the ruling immediately and shall issue an order to release the witness. 8. An immediate complaint may be filed against a ruling made pursuant to paragraphs 1 and 2. In such cases, Article 410 shall not apply. This article wholly amended on June 1, 2007. Article 152. Disobedience to summons and custody. A witness who does not obey a summons without good cause may be taken into custody. Article 153. Provisions applicable mutatis mutandis. At Articles 73, 74 and 76 shall apply mutatis mutandis to the summons of a witness. Article 154. Summons of witness within precinct of court. A witness who is within the precinct of a court may be examined without summons. Article 155. Provisions applicable mutatis mutandis. At Articles 73, 75, 77, 81 through 83, and 85, 1, and 2, shall apply mutatis mutandis to taking a witness into custody. Article 156. Oath of witness. A witness shall be required to take an oath before being examined, provided that the same shall not apply where otherwise provided in acts. Article 157. Form of oath. 1. The oath shall be based on a written oath. 2. The written oath shall be as follows. I swear that I will speak the truth, the whole truth and nothing but the truth according to my own conscience, and if there is any falsehood in my statement, I shall be punished for perjury. 3. A presiding judge shall have a witness read the written oath and print his, her name and affix his, her seal thereon or write his, her signature. Provided that if the witness is not able to read or sign the written oath, court officials who participate in the trial shall act for him, her. 4. The oath shall be taken solemnly in the state of standing up. This article wholly amended on December 8, 2020. Article 158. Admonishment to sworn witness. A presiding judge shall admonish the witness to be aware of the punishment for perjury before being sworn. Article 159. Disability of oath. Any of the following witnesses shall be examined without being sworn. 1. Person under 16 years of age. 2. Person who cannot understand the meaning of an oath. Article 160. Notice of rights to refuse to testify. A witness referred to in Article 148 or 149 shall be instructed by a presiding judge before being examined that she may refuse to testify. Article 161. Refusal of oath or of witness and administrative fines. 1. When a witness refuses to swear or testify without good cause, she may be subject to an administrative fine not exceeding 500,000 won, by a ruling. Less than amended on January 25, 1973, December 29, 1995 greater than. 2. An immediate complaint may be filed against a ruling referred to in paragraph 1. Less than amended on December 29, 1995 greater than. Article 161-2. How to examine witness. 1. A witness shall be examined first by the party, prosecutor, defense counsel, or criminal defendant, who requested his/her appearance, and then by the other party, prosecutor, defense counsel, or criminal defendant. 2. The presiding judge may examine the witness after the examination referred to in the preceding paragraph is completed. 3. The presiding judge may, if deemed necessary, irrespective of the preceding two paragraphs, examine the witness at any time, and may change the order of the examination referred to in paragraph 1. 4. The method of examination of a witness who is to be examined by the court ex officio or on the application of a victim due to a crime, shall be determined by the presiding judge. Less than amended on November 28, 1987 greater than. 5. A member of a collegiate court may examine a witness after notifying the presiding judge to do so. This article newly inserted on September 1, 1961. Article 162, Separate Examination and Confrontation. 1. Examination of witness shall be made of each of the witnesses. Less than amended on September 1, 1961 greater than. 2. Where a witness who has not been examined is present in court, she shall be ordered to leave court. 3. Where necessary, a witness may be cross-examined with other witnesses or the criminal defendant. 4. Deleted. Less than September 1, 1961 greater than. Article 163. Right for presence and for examination of relevant party. 1. A prosecutor, the criminal defendant, or her defense counsel may be present at the examination of a witness. 2. Notice of the date and place of the examination of a witness shall be given in advance to the persons who are entitled to be present at the examination pursuant to the preceding paragraph, provided that where they announce clearly their desire not to be present, the foregoing shall not apply. Article 163-2. Presence of persons with reliable relationship. 1. When a court has a victim of a crime sit in the witness box for examination, the court may, if deemed that the victim is likely to feel severe uneasiness or tension in light of the age of the witness, her physical or mental state, or any other circumstances, allow a person who has a reliable relationship with the victim to sit in company with the victim, ex officio or upon a motion of the victim, her legal representative, or the prosecutor. 2. If a victim of a crime is less than 13 years of age, or incompetent to discern right from wrong or make a decision due to her physical or mental disability, the court shall allow a person who has a reliable relation with the victim to sit in company with the victim, unless such company is likely to cause a trouble in the proceedings or there is any inevitable reason otherwise. 3. A person who sits in company under paragraph 1 or 2 shall not interfere with the examination by the court, examination of an involved in the litigation, or testimony of a witness, nor commit any act that is likely to give an undue influence on the contents of testimony of the witness. 4. The scope of persons who have a reliable relationship and thus are allowed to being present in company under paragraph 1 or 2. The procedure for and manner of being present in company, and other necessary matters shall be prescribed by the Supreme Court regulations. This article newly inserted on June 1, 2007. Article 164, Demand of Inquiry. 1. Where a prosecutor, the criminal defendant, or her defense counsel does not take part in the examination of a witness, they may request the court to inquiry into necessary matters. 2. Where the testimony of a witness without the presence of the criminal defendant or her defense counsel contains an unexpected and serious statement which is disadvantageous to the criminal defendant, the court shall give notice of the contents of such statement to the criminal defendant or her defense counsel. 3. Deleted. Less than September 1, 1961 greater than. Article 165. Examination of witness outside court. A court may summon a witness to a place other than the courtroom for examination or may examine him, her at the place where she is, after hearing the opinion of the prosecutor, the criminal defendant, or her defense counsel and taking into consideration her age, vocation, health condition, and other special circumstances. Article 165-2. Examination of witness through video or other transmission system. 1. If deemed appropriate when it examines any of the following persons as witness, a court may examine the person through a video or any other transmission system or install a partitioning facility to place the person behind the facility for examination after hearing opinions of the prosecutor and the criminal defendant or her defense counsel. Less than amended on June 9, 2009, August 4, 2011, December 18, 2012, December 8, 2020, August 17, 2021 greater than. 1. A victim of a crime referred to in Article 7111, 1-2, 2, and 3 of the Child Welfare Act. 2. A child, youth, or victim who has been targeted for a crime referred to in Articles 7, 8, 11 through 15, and 17, 1, of the Act on the Protection of Children and Youth Against Sexual Abuse. 3. A person who is deemed likely to lose peace of mind substantially due to psychological burden when the person testifies in confrontation with a criminal defendant or any other person, in light of the nature of the crime involved, the age of the witness, his/her physical or mental state, the relation with the criminal defendant, or any other circumstances. 2. When the court deems that a witness has difficulty in appearing before the court because he/she resides in a remote or barely accessible area or due to other circumstances, such as health conditions, it may examine him/her through a video or any other transmission system after hearing opinions from the public prosecutor and the defendant or his/her defense counsel. Less than newly inserted on August 17, 2021 greater than. 3. The examination of a witness under paragraphs 1 and 2 shall be deemed the examination of a witness through appearance in court. Less than newly inserted on August 17, 2021 greater than. 4. Matters necessary for the examination of a witness under paragraphs 1 and 2 shall be prescribed by the Supreme Court regulations. Less than newly inserted on August 17, 2021 greater than. This article newly inserted on June 1, 2007. Article 166, Order to proceed in custody. 1. When deemed necessary, a court may order a witness to proceed to a designated place in company, by its ruling. 2. A witness may be taken into custody when he/she refuses the foregoing order without any good cause. Article 167, Commissioned Judge and Requisitioned Judge. 1. Where a witness is to be examined outside the court, a court may order a member of a collegiate court to conduct such examination or may request a judge of a district court at the place where the witness is actually present to do so. 2. The requisitioned judge may, if the witness is not in his/her jurisdiction, request a judge of another district court which has the jurisdiction over the place where he/she is at present to make the examination. 3. The commissioned judge or requisitioned judge may adopt necessary measures to examine a witness in jurisdiction of another court or presiding judge. Article 168, Traveling expenses, daily allowances, and lodging expenses for witnesses. A witness may demand traveling expenses, daily allowance, and lodging expenses in accordance with Acts, provided that this shall not apply if, without good reason, he/she refuses to swear or to testify. Chapter 13, Expert Evidence. Article 169, Expert Evidence. A court may order a person of learning or experience to give an expert evidence. Article 170, Oath. 1. An expert witness shall take an oath before expert evidence is given. 2. The oath shall be based on a written oath. 3. The written oath shall be as follows. I swear to give an expert opinion faithfully according to my own conscience, and if there is any falsehood in my statement, I shall be punished for the false expert opinion. 4. Articles 157, 3, and 4, and 158 shall apply mutatis mutandis to the oath of an expert witness. Article 171, Report on expert evidence. 1. As regards a process or result of expert evidence, the expert witness shall submit it in writing. 2. Where there are 2 or more expert witnesses, they shall be required to submit reports individually or jointly. 3. The reason behind expert opinions shall be clearly stated. 4. If necessary, the expert witness shall be required to explain his/her opinion. Article 172, Expert Evidence Outside Court. 1. If necessary, a court shall allow the expert witness to give an opinion outside the court. 2. In case of the preceding paragraph, articles needed for an inspection may be delivered to the expert witness. 3. When expert evidence is required in respect to the mental or physical condition of the criminal defendant, a court may, if necessary, confine the criminal defendant in a hospital or other suitable place for a fixed period, and when it is completed, the confinement shall be terminated without delay. 4. When the confinement referred to in the preceding paragraph is required, a warrant of confinement for expert opinion shall be issued. Less than amended on January 25, 1973 greater than. 5. If it is necessary for the confinement under paragraph 3, the court may order judicial police officers to serve as guards of the criminal defendant, ex officio or upon request of administrators of hospitals or other places where the criminal defendant is to be confined. Less than newly inserted on January 25, 1973 greater than. 6. If necessary, the court may extend or shorten the period of confinement. Less than newly inserted on January 25, 1973 greater than. 7. The provisions on detention shall apply mutatis mutandis to the confinement under paragraph 3, unless otherwise provided in this Act, provided that exceptions shall be made to the provisions on release on bail. Less than newly inserted on January 25, 1973 greater than. 8. The confinement under paragraph 3 shall be regarded as detention in inclusion of the number of days of unconvicted detention. Less than newly inserted on January 25, 1973 greater than. Article 172-2. Confinement for expert opinion and detention. 1. When a warrant of confinement for expert opinion is executed against the criminal defendant under detention, it shall be regarded that during the period of the confinement of the criminal defendant, execution of the detention is suspended. 2. In the case of paragraph 1, when the disposition of the confinement under paragraph 3 of the preceding article is cancelled or confinement period expires, it shall be regarded that the suspension of execution of detention is cancelled. This article newly inserted on January 25, 1973. Article 173. Necessary disposition by expert witness. 1. When it is necessary for the purpose of furnishing expert evidence, an expert witness may, with the permission of a court, enter the dwelling of a person, premises, buildings, airplanes, vessels, or vehicles which are guarded by persons or may examine a person, dissect a corpse, open a grave, or destroy things. 2. On granting the permission referred to in the preceding paragraph, a court shall issue a warrant of permission, in which the name and the offense of the criminal defendant, the place to be entered, the person to be examined, the corpse to be dissected, the grave to be opened, the things to be destroyed, the name of the expert witness, and the effective period shall be entered. 3. The expert witness shall present the warrant of permission to the person who is subject to the disposition referred to in paragraph 1. 4. The provisions of the preceding two paragraphs shall not apply to the dispositions referred to in paragraph 1, which are effected by an expert witness in the courtroom. 5. Articles 141 and 143 shall apply mutatis mutandis to paragraph 1. Article 174. Presence or question by expert witness. 1. Where necessary, the expert witness may inspect or copy documents and evidence with permission of the presiding judge and may be present at the examination of the criminal defendant or witness. 2. An expert witness may demand examination of the criminal defendant or witness or may examine him, her directly by permission of the presiding judge. Article 175. Commissioned judge. A court may require a member of a collegiate court to take necessary measures in respect of expert evidence. Article 176. Presence of parties. 1. The prosecutor, the criminal defendant, or the defense counsel may be present at an examination or inquiry by an expert witness. 2. Article 122 shall apply mutatis mutandis to the preceding paragraph. Article 177. Provisions to be applied mutatis mutandis. At Chapter 12, excluding the provisions concerning custody, shall apply mutatis mutandis to expert evidence. This article wholly amended on December 8, 2020. Article 178. Traveling expenses and fees for expert witness. An expert witness may demand fees for his, her opinion and reimbursement of any subrogated amount, in addition to traveling expenses, daily allowances, and lodging expenses, under the conditions as prescribed by acts. Article 179, Expert Witness. Where a person is examined in regard to facts in the past which she comes to know by virtue of special knowledge, it shall be governed by the provisions of the preceding chapter, instead of those of this chapter. Article 179-2. Request of expert evidence. 1. The court may, if it is deemed necessary, request the expert evidence of public offices, schools, hospitals, or other associations or agencies equipped with appropriate facilities. In such cases, the provisions concerning oath shall not apply. 2. In the case of paragraph 1, the court may request a person designated by such public offices, schools, hospitals, associations, or agencies, to explain the document of expert evidence. This article newly inserted on December 29, 1995. Chapter 14, Interpretation and Translation. Article 180, Interpretation. A statement by a person not versed in the Korean language shall be required to be interpreted by an interpreter. Article 181, Interpreter for deaf or mute. A statement by deaf or mute person may be required to be interpreted by an interpreter. This article wholly amended on December 8, 2020. Article 182, Translation. Letters, signs, or marks not in the Korean language shall be translated. Article 183, Applicable Provisions. The provisions of the preceding chapter shall apply mutatis mutandis to interpretation and translation. Chapter 15, Preservation of Evidence. Article 184, Request and Procedure for Preservation of Evidence. 1. When there are circumstances which may make it impracticable to use evidence unless it is preserved in advance, the prosecutor, the criminal defendant, a criminal suspect, or his/her defense counsel may request a judge to effect such measures as attachment, investigation, verification, examination of witness, or expert opinion, even prior to the date for the first trial. 2. The judge who has received the request prescribed in the preceding paragraph shall have the same authority as a court or presiding judge has, regarding the disposition of such request. 3. When making the request referred to in paragraph 1, the person shall offer presumptive proof as to the reason in writing. 4. A complaint against a ruling to deny a request under paragraph 1 may be filed within 3 days. Less than newly inserted on June 1, 2007 greater than. Article 185, Inspection of Documents. A prosecutor, the criminal defendant, a criminal suspect, or a defense counsel may inspect and also copy documents and evidence relating to the disposition referred to in the preceding article with permission of a judge. Chapter 16, Costs of Litigation. Article 186, Costs of Litigation borne by criminal defendant. 1. In pronouncing a sentence, the court shall have the criminal defendant bear the whole or part of the trial costs, provided that this shall not apply where the criminal defendant fails to pay the trial costs due to his/her financial circumstances. Less than amended on December 29, 1995 greater than. 2. Even where no sentence has been pronounced, any costs which have arisen from a cause imputable to the criminal defendant may be charged to him. Article 187. Costs of litigation borne by accomplices. The costs of the litigation against accomplices may be borne jointly by them. Article 188. Costs of litigation borne by complainant. If the criminal defendant is rendered a judgment of not guilty or acquittal in respect of a case prosecuted upon criminal complaint or accusation, the complainant or accuser may be required to bear, in whole or in part, the costs of the litigation if it is found that she acted willfully or by gross negligence. Article 189. Withdrawal of appeal by prosecutor and costs of litigation. Where only a prosecutor has taken an appeal or requested a retrial and the appeal taken or retrial requested has been dismissed or withdrawn, the criminal defendant shall not be required to bear the costs of the litigation. Article 190. Costs of litigation borne by third party. 1. If an appeal or retrial instituted by a person other than a prosecutor is dismissed or withdrawn, such person may be required to bear the costs connected with the appeal or retrial. 2. The provisions of the preceding paragraph shall apply where an appeal or a retrial lodged by the criminal defendant is withdrawn by a person other than the defendant. Article 191. Decision on costs of litigation. 1. When the criminal defendant is required to bear the costs of litigation where the proceedings are terminated by decision, the decision relating to such costs shall be rendered ex officio. 2. Against such decision referred to in the preceding paragraph, an objection may be raised only when an appeal is made against merits in the decision. Article 192. Decision on costs of litigation borne by third party. 1. When a person other than the criminal defendant is required to bear the costs of litigation where the proceedings are terminated by decision, a ruling for the purpose shall be rendered ex officio. 2. An immediate complaint may be filed against the ruling referred to in the preceding paragraph. Article 193. Completion of procedures not by trial. 1. When the costs of litigation are to be borne where the proceedings are terminated otherwise than by decision, a ruling on costs shall be rendered ex officio by the court in which the case was last pending. 2. An immediate complaint may be filed against the ruling referred to in the preceding paragraph. Article 194. Fixing amounts of costs to be borne. If the decision ordering the costs of litigation to be borne does not fix the amount of such, the same shall be fixed by the prosecutor responsible for the execution of the order. Article 194-2. Judgment of acquittal and compensation for expenses. 1. If a judgment of acquittal is finally affirmed, the state shall be liable for the expenses incurred to the person who was a criminal defendant in the relevant case for defending his/her case on trial. 2. In any of the following cases, the liability for the expenses under paragraph 1 may be discharged completely or partially. 1. Where it is found that the person who was the criminal defendant deemed has been prosecuted made a false confession or fabricated an evidence for guilt with an intention to mislead the investigation or trial. 2. Where a judgment of acquittal is finally affirmed for one part of crimes in the trial, but a judgment of guilt is finally affirmed for the other part of crimes at the same time. 3. Where a judgment of acquittal is finally affirmed on any of the grounds under Article 9 or 10(1) of the Criminal Act. 4. Where such expenses have been incurred due to a cause for which the person who was a criminal defendant shall be culpable. This article newly inserted on June 1, 2007. Article 194-3. Procedure for compensation for expenses. 1. The compensation for expenses under Article 194-2, 1, shall be, upon receiving a request from the person who was a criminal defendant, decided by a collegiate division of the court that made the judgment of acquittal. 2. The request under paragraph 1 shall be filed within 3 years from the date on which the person comes to know that the judgment of acquittal has become final and conclusive, and 5 years from the date on which such judgment became final and conclusive. less than amended on December 30, 2014 greater than. 3. An immediate complaint may be filed against a decision under paragraph 1. This article newly inserted on June 1, 2007. Article 194-4. Scope of compensable expenses. 1. The expenses compensable under Article 194-2 shall be limited to the expenses incurred to the person who was a criminal defendant or his/her defense counsel, such as travel expense, daily allowance, and accommodations, in preparing for and attending trials, and the remuneration for the person who was a defense counsel. In such cases, the Criminal Procedure Costs Act shall apply mutatis mutandis to the compensable amount, but the provisions thereof concerning witnesses shall apply mutatis mutandis to criminal defendants, while the provisions thereof concerning the court-appointed defense counsel shall apply mutatis mutandis to defense counsel. 2. If there are two or more defense counsel involved in preparing for or attending trials, the court may limit the travel expense, daily allowance, and accommodations for defense counsel to the expenses incurred to the representative defense counsel or some of other defense counsel, considering the nature of the case, the status of proceedings, and other circumstances. This article newly inserted on June 1, 2007. Article 194-5. Provisions applicable mutatis mutandis. The claim of compensation for expenses, the procedure for compensation for expenses, the correlation between compensation for expenses hereunder and compensation for damages under other acts, the assignment and seizure of a right to compensation, or the compensation for expenses payable to the heir to the person who was a criminal defendant shall be made in accordance with the practices of compensation under the Criminal Compensation Act, except as otherwise provided in this Act. This article newly inserted on June 1, 2007. Part 2 Court of First Instance. Chapter I Investigation. Article 195. Relationship between prosecutors and senior judicial police officers. 1. Prosecutors and senior judicial police officers shall cooperate with each other with respect to investigations and the institution and maintenance of prosecutions. 2. Matters regarding general criminal investigation rules that shall be complied with in conducting investigations under paragraph 1 shall be prescribed by presidential decree. This article newly inserted on February 4, 2020. Previous Article 195 moved to Article 196. Article 196. Investigation by prosecutor. Where there is a suspicion that an offense has been committed, a prosecutor shall investigate the offender, the facts of the offense, and the evidence. This article wholly amended on February 4, 2020. Moved from Article 195. Previous Article 196 moved to Article 197 less than February 4, 2020 greater than. Article 196. Investigation by prosecutor. 1. Where there is a suspicion that an offense has been committed, police administrative officers, police superintendents, police captains, or police lieutenants shall investigate the offender, the facts of the offense, and the evidence, while serving as senior judicial police officers. Less than amended on February 9, 2022 greater than. 2. A public prosecutor may investigate a case transferred by a judicial police officer pursuant to Articles 197-3, 6, 198-2, 2, and 245-7. 2. To the extent that the identity of the case concerned is not undermined. Less than newly inserted on May 9, 2022 greater than. This article wholly amended on February 4, 2020. Moved from Article 195. Previous Article 196 moved to Article 197 less than February 4, 2020 greater than. Enforcement date, September 10, 2022, Article 196. Article 197, Judicial Police Officers. 1. Where there is a suspicion that an offense has been committed, police administrative officers, police superintendents, police captains, or police lieutenants shall investigate the offender, the facts of the offense, and the evidence, while serving as senior judicial police officers. Less than amended on February 4, 2020 greater than. 2. Police sergeants, senior patrol officers or patrol officers shall assist in the investigation of crimes, as junior judicial police officers. Less than amended on February 4, 2020 greater than. 3. Deleted. Less than February 4, 2020 greater than. 4. Deleted. Less than February 4, 2020 greater than. 5. Deleted. Less than February 4, 2020 greater than. 6. Deleted. Less than February 4, 2020 greater than. This article wholly amended on July 18, 2011. Moved from Article 196, previous Article 197 deleted. Article 197 to 2. Demand for further investigation. 1. A prosecutor may demand a senior judicial police officer to conduct further investigation in any of the following cases. 1. Where necessary in order to determine whether to prosecute a transferred case or to maintain the prosecution. 2. Where necessary in order to determine whether to request a warrant applied for by the senior judicial police officer. 2. In receipt of a demand under paragraph 1, the senior judicial police officer shall without delay conduct further investigation, and notify the prosecutor the results thereof. 3. When the senior judicial police officer fails to comply with the demand under paragraph 1, without justifiable reasons, the prosecutor general or the chief prosecutor of a prosecutor's office of any level may demand a person with an authority to remove him or her from his or her duties or to take disciplinary actions against him or her, and the disciplinary procedures shall comply with the decree on disciplinary action against public officials or the decree on disciplinary action against police officials. This article newly inserted on February 4, 2020. Article 197 to 3. Demand for corrective measures. 1. Where a prosecutor receives a report or becomes aware of facts involving a suspected breach of statutes or regulations, violation on human rights, or manifest abuse of investigative authority in the course of investigation by a judicial police officer, he or she may demand a senior judicial police officer to transmit a certified copy of the case record to him or her. 2. Upon receiving a demand for transmission under paragraph 1, the senior judicial police officer shall without delay transmit the certified copy of the case record to the prosecutor. 3. The prosecutor in receipt of the transmission under paragraph 2, may demand the senior judicial police officer to take corrective measures if deemed necessary. 4. The senior judicial officer in receipt of the demand for corrective measures under paragraph 3, shall without delay comply with the demand unless there is a justifiable reason not to do so, and shall notify the prosecutor the results thereof. 5. The prosecutor in receipt of the notice under paragraph 4, may demand the senior judicial police officer to transfer the case where it is deemed that the corrective measures under paragraph 3 have not been implemented without justifiable reasons. 6. Upon receiving the demand for transfer referred to in paragraph 5, the senior judicial police officer shall transfer the case to the prosecutor.